Good morning, everyone. We have 5 cases on this morning's argument calendar, and we'll begin with appeal number 223140, the United States versus Thomas Osadzinski. Mr. Herman, nice to see you. Good morning.
Good morning, Judge Scudder, Judge Wood, Judge St. Eve. May it please the court. My name is Josh Herman, and I am here on behalf of defendant appellant Thomas Osadzinski. This is a unique and important case with significant First Amendment consequences. Mr. Osadzinski was a 20-year-old junior at DePaul University when he was arrested in November of 2019 and eventually charged and then subsequently convicted after a jury trial of attempting to provide material support to ISIS in the form of services, ISIS being a designated foreign terrorist organization in violation of 18 U.S.C. 2339b. However, Mr. Osadzinski did not commit or attempt to commit any act of violence. He did not attempt to travel overseas or actually travel overseas. He did not send money or try to send money to ISIS. And quite to the contrary, as established in the record, when given multiple opportunities by undercover government operatives to do something for ISIS, such as translations or sending screenshots of the computer script, he denied, he demurred, he delayed, and he ultimately ignored.
So, Mr. Herman, what he seems to have done, but please correct me if I'm not reading the record right, is he seems to have written this code designed to thwart efforts to take down ISIS messages, that if it was taken down, this thing somehow propagated the item that was taken down and brought it back out, and that ISIS itself had called for measures to thwart these takedown efforts. It was part of its international, I guess, presence. I'm not sure whether it was recruitment or just information. So do I understand your position is just writing this computer code alone was not enough to constitute an attempt at material assistance?
Yeah, yes, Judge, and there's a lot to unpack there, and I think it touches on both our First Amendment vagueness arguments, also the due process as applied, and it bleeds into the sufficiency arguments as well. But if I can clarify one point, a couple of points about this code. So we're talking, at trial, it was called the NASP, NAS.PY computer
Python,
code. It's a code in the Python computer language, and he did not actually write the code. The code was out in the universe. There was a stipulation that the parties entered into.
He created the program, though, didn't he?
No.
With the code?
No, Your Honor. He made slight modifications to it, which was the best the evidence, I think, at trial established that there was another individual aptly named No Name that the government never identified and never, more importantly, never said was a member of ISIS.
What about his own statements that he had created it?
Those statements, there were a lot of statements from Mr. Osadzinski that I think we can chalk up to bluster, such as my favorite weapon is a Kalashnikov when he had never touched a gun before.
But certainly from the sufficiency of the evidence point, and that we're looking at things in the light most favorable to the government, I don't think we could chalk it up to that.
Well, from the sufficiency of the evidence, I think the more important question is whether or not there was an attempt to act under the direction or in coordination with ISIS as opposed to operating the code. Somebody could take this code and send it along directly to ISIS, and even if they had not authored it, that perhaps could be evidence that would weigh in the government's favor on the sufficiency side. The more important point is the direction and coordination element. And to Judge Wood's point in, what is the argument here from a First Amendment perspective? If you would even use this code, and this is where I want to be very clear about what the code actually did. The code copied and forwarded ISIS videos from one private Telegram channel to another private Telegram channel. So we are not talking about distribution to the general public. We are not talking about content creation. We are talking very narrowly about copying between private Telegram channels. And just to be sure we're on the same page, Telegram is a social media application, and a channel could be essentially a private chat group. You could have one person in there, you could have multiple people in there. And we saw from the evidence at trial that there was a channel created with the undercover online covert employee known as OCE4. But the key issue from a First Amendment perspective here, which we focus on, and which is why I began with talking about this as a case of First Amendment consequence, is that the direction and coordination theory here is essentially that once ISIS says support us online, or any FTO, if somebody does any type of act to then express advocacy or support for ISIS or any foreign terrorist organization online subsequent to that call, it eliminates the right to engage in any type of independent advocacy.
Go ahead.
No, go ahead.
I was going to say, so I think you're touching on the language from the Boehm case about how people can say, I love ISIS, or they can say, I'm a supporter of ISIS, as long as all they're doing is talking and expressing their viewpoint about ISIS. But I want to make sure, again, I want to understand your argument. I thought that to accept your argument, it was necessary to accept that ISIS couldn't act through an intermediary. I think everybody agrees OCEs 1 through 4 were not, he didn't even think they were ISIS people. He thought they were fellow travelers, but he thought they were communicating ISIS's views. So I saw it as an agency issue. I saw it as, is it impossible in your view for ISIS to act through an intermediary?
No, and I think that's an important point of distinction when we look at other material support cases, some in from this circuit, but mainly from other circuits. Typically, you would find in a material support case, in a 2339B case, a government agent posing as somebody who has a direct conduit to ISIS. And we saw that here in multiple occasions with OCE1, or I believe OCE3, saying, I have this 2-page translation, and I'm going to, from Arabic for bomb-making instructions, can you translate it to English and provide it to ISIS? OCE4 said, send me screenshots so I can send them to ISIS. And Mr. Ozezinski didn't follow through with either of those. And it's not necessarily just the Boehm case, which actually predates and foreshadowed, more importantly, the Humanitarian Law Project case, which then requires...
Does it matter, and I'm sorry to interrupt you, you can incorporate it in, does it matter, though, that this was charged as an attempt?
That's actually the attempt charge in this case, Your Honor, posed a bit of a conundrum here, especially when we see that the government, in its brief here, towards the end in a footnote, says he actually did provide material support. And I think this gets to the nut of the vagueness in our due process arguments about when does one attempt to provide advocacy in support of a foreign terrorist organization? Where did the attempt occur here? It looks to us more not like an inchoate offense, but he actually, under the government's theory, he actually provided material support by advocating in support of ISIS and simply copying and forwarding videos.
But we don't have to find that or rely on that since he was convicted of attempt, correct?
He was convicted of attempt, but that again begs the question of how can an attempt to provide independent advocacy exist when there is a right to independent advocacy? When does one, like get halfway through a sentence supporting ISIS? Forwarding a video to somebody and the video is never seen, like the tree falling in the forest. The attempt cases don't fit in a case where you're not dealing with a fungible good or fungible training, such as like in Humanitarian Law Project. We're talking about fungibility. Advocacy is not fungibility, and this is a point I think the ACLU makes very, very well in its amicus brief here. We are not talking about the core concerns that were in HLP, where we are dealing with plaintiffs who are speaking directly in a pre-enforcement action to the PKK and the LTTE, two foreign terrorist organizations, seeking to provide them with training so they could advocate on behalf of themselves and potentially obtain weapons. That was the nut of the concern.
Mr. Herman, can I take you back to a little bit of a strand of what Judge Wood was asking you about? And that is, I totally understand, and I think you do quite a good job in your brief at expressing a concern with the statute being used to prosecute individuals that just, generally respond to a call to continue a propaganda campaign or to articulate support for an organization. Where I have difficulty, and I totally get that, it's a hard line drawing question in this area. What I wonder about, though, is does it break down for you factually here? And the reason is because, in keeping with Judge Wood's observation, it seems to me, these are my words, not anybody else's, okay, that the defendant kind of self-deputized himself as a member of the ISIS media organization, as a member of the Dewan, in an effort to help the organization stay ahead of efforts by Western governments, including the United States, to shut down ISIS propaganda. And that's what his script was designed to do, to kind of help stay. So the nexus seems tighter than the concern. The nexus factually seems tighter than the concern that you're articulating in your brief. How's that view mistaken?
Sure. So we're getting more into the sufficiency side of things, and I'll hit the points as quickly as I can to save time for rebuttal. He did not self-deputize himself as a part of the D1. He identified himself as a supporter. The word that he used was munasir, M-U-N-A-S-I-E-E-R, not an actual member of ISIS. The direction, again, from the government's theory was this video called Inside 8, which was to support us online. This was one of thousands of videos that he had, and it was, while he made some comments about seeing it.
But not generally support, right? Support in a way to stay ahead of these efforts that are taking down, or as Judge Wood put it, thwarting the organization's media campaign.
Right. So he that in itself, if you go back to the other service, and I think, again, focus on the services that were here. We were talking about looking specifically at the document called Heralds of the Internet. And exactly, I'm not sure I'm going to correctly quote Your Honor, but when you said he took it upon himself, that is in essence independent action. In independent action, according to HLP, even if independent action in advocacy has confers some type of benefit to the foreign terrorist organization, it's still legal. So somebody could, even if ISIS said, we want everybody in the world to see our videos, somebody could say, or independently take it upon themselves to spread those videos and those messages. If I haven't answered your question fully, I'd
No,
like
you
to
haven't.
reserve the rest.
We'll give you. We're going to give you rebuttal time. Okay. So keep going.
Okay. And again, this document called Heralds of the Internet, it was the government that described it as a manifesto. It was a personal statement with a personal intent in the beginning of his own particular viewpoint. We may find that viewpoint completely disagreeable, but as the ACLU said in its brief, in which we echo, this court has an honored history of protecting disfavored viewpoints in light of the First Amendment. What the government's theory here, this is in the closing rebuttal argument at page 1422. There's two poles, according to the government. You can be completely isolated from an FTO and then say whatever you want, or you're working under direction and in coordination with it. But that's not the law, and it's impossible to be completely isolated because it punishes those who exercise an inherent First Amendment
But given
right.
the jury instructions here, the jury could not have convicted based on the isolation theory, because the jury instructions were very clear that this had to be done at the direction of and in coordination with ISIS.
We submit that this is a case that should not have gone to the jury, and the Rule 29 should have been granted because the theory in and of itself allowed for Mr. Ozazinski to be convicted based on First Amendment conduct, based on a theory that where direction is derived from the exercise of First Amendment rights, and the theory nullifies the existence of independent advocacy. I'd like to reserve the rest of my time.
Can I ask you one more question? We'll give you your rebuttal time. Okay. Can you help me just step back one second? One aspect of your appeal, if I understand it, is there's three issues that you've put in front of us. You got the Fifth Amendment void for vagueness. You've got the straight up sufficiency of evidence challenge, and then kind of in between there you have an argument that the conviction offends the free speech clause of the First Amendment.
Correct.
Okay. Can you focus just for a second on that middle claim, the free speech clause challenge?
Right.
Is that a strand of the sufficiency of evidence challenge, or is it something distinct?
I think it's,
go ahead.
sorry. I think it's distinct, but I recognize how it can bleed into it because as any as applied challenge, you have to look at the facts, and Judge Gettleman in his Rule 29 ruling basically said, I've looked at the facts, I've heard the facts after making, after sitting through the trial.
Yeah, that's exactly the point. I can't, if it's not like a subsection or a separate aspect of the sufficiency of evidence challenge, what I was confused about in preparing for this is how do you conduct judicial review of it? And the reason I'm asking that question is because your brief very much seems to focus not only on the pretrial ruling. Judge Gettleman wrote an opinion denying the challenge or denying the motion to dismiss the indictment, but you also seem to focus on what happened at trial, and therefore you have an evidentiary focus.
Correct. We think the issues should be parsed out, where the First Amendment argument, even if you accept the government's theory, even if you accept all of the facts, even if you accept that he listened to ISIS saying, we want other people to see our
So
video.
is that to say then that we should, yes, we can go ahead and invoke the standard of review that ordinarily applies to sufficiency challenges, and we just ought to ask a precise question here. Could a rational jury have concluded that a violation of this statute did not offend his free speech rights? Is that the right question to ask, however it comes out?
I think the right question is using the standard of de novo review for a First Amendment challenge here, which is whether or not accepting the facts as true, that can direction derive from a call from a foreign terrorist organization to others to support it online. Can there be, so the issue in a nutshell from this case and why we think it is a truly important First Amendment case is whether or not there is a right to independent advocacy in the digital age, because FTO propaganda is ubiquitous. We noted in footnote 1 of our
So
report.
you may be right. I mean, I think it's a tricky little question. Just conduct review of the theory of prosecution as applied.
Correct. And then we have, again, the sufficiency evidence on the back end, and in between, I think the in-between argument is the notice argument.
Okay,
Thank you.
we'll give you your rebuttal time. We'll hear from the government.
Good morning, and may it please the Court. Melody Wells for the United States. The Supreme Court has upheld the constitutionality of Section 2339B in the face of defendants' challenges. Specifically, Humanitarian Law Project held that services is not impermissibly vague. It also held that while the First Amendment protects independent advocacy, it does not protect conduct or speech that is done at the direction of a foreign terrorist organization like ISIS. A properly instructed jury found that defendant was no independent advocate, finding instead that he acted at ISIS's direction, and they did so based on ample evidence that on appeal, this court views in the light most favorable to the government. That evidence showed that ISIS directed supporters like defendant to assist it in keeping ISIS accounts and information online when social media applications were removing terrorist content.
Ms. Wells, where's the line on direction and control? How much does there have to be? Because the argument is these general calls through videos and other social media apps really can never amount to direction or control.
Your Honor, the government disagrees. What defendant would have us look at this as an all or nothing proposition, that it cannot be a public request and that cannot amount to direction and control. But what the defendant attempts to do is to excise everything that happened in between ISIS issuing this directive through, for example, the Inside 8 video, which the government, of course, acknowledges was a public directive. That's the way these organizations like ISIS operate. But the defendant ignores every...
You didn't put the full video in the record, is that correct?
That's correct, Your Honor. The government, both on its own and in response to defendants' objections, did not put in images of violence. Inside 8 contained those types of images. We admitted clips that contained the relevant portions to the directives. There is some limited testimony from witnesses about the kind of violent imagery that appeared in some of these videos, but we did not show that type of information to the jury.
And no one is contesting the standalone accuracy or legitimacy of what you did put in? I'm saying the rule of completeness and things like that, you know,
No, Your Honor, none of that was challenged, and again, this was really to address objections made by the defense team and concerns that the court raised, and of course the government's, you know, concern with putting that kind of information before the jury. There is no challenge to the completeness of this record in that way at all, Your Honor.
Can I stay with that question? Were the clips of Inside 8 and the other one was what, Structure of the Khalifa?
Yes, those were 2 of the videos.
Okay. Are the clips part of the evidentiary record even if the full videos are not?
Yes, the clips are part of the evidentiary record. We've sent those up and they're available to the court as well for consideration here.
Okay, they're actually not. I believe you that they're part of they're part of the trial record. You know that better than I would, but we can't access them. I looked for them. I tried. They're not on the record that was transmitted to our court.
Your Honor, I will check on that. It is my recollection that they were included in our motion to supplement the record with the district court. I will investigate why those clips were not made available. That order was granted in full, and I'll see what happened.
Yeah, perhaps you
with
can
that
work,
order.
just if you can work with Mr. Herman. I mean, there's a lot of issues that are contested, but hopefully we're not disagreeing about what the evidence was that was before the jury. Then we can argue about what it means and all that.
It is not my understanding, and I'll defer to Mr. Herman, that there's any disagreement about the evidence itself. But turning back to Judge St. Eve's question, one thing that the defendant attempts to do is to take out everything that happened between this video existing and the fact that he saw it and his creation of this computer program, when in fact the evidence shows that he knew about the directive, he talked about it, he shared it with others, he sent screenshots to people that he believed were
so
working
why
for
does
ISIS.
that all add up to accepting direction from them? You can know about all sorts of things, and if you were just standing on the street corner over at the Federal Plaza handing out pamphlets that said these things, wouldn't you agree that that's simply a way of exercising your First Amendment rights?
A person is entitled to stand on the street corner outside any building in the United States and hand out pamphlets, Your Honor. That would not be standing alone any evidence of a crime. that was
Even
committed.
if the organization that is lauded in the pamphlets is one that says, we hope people will take every possible step to disseminate our message.
That is correct, Your Honor. But as Humanitarian Law Project pointed out, there is a difference between advocating for a cause and providing a service to an organization that advocates for the same cause.
Doesn't that skip over the question, though, of the first directive or any subsequent directive, how specific that directive needs to be? Because you said, well, here's the directive, and then he did all these other things. But isn't the question on the line drawing, how specific does that directive have to be in the first place in order to qualify for services?
Your Honor, I think that Humanitarian Law Project holds that someone needs to act at the direction of or in coordination
Right.
with an FTO.
Which I don't think answers the question of how specific does that directive or requested coordination need to be?
The ordinary understanding of a directive would be a command or an instruction by another person or entity. I'm not aware.
To do what, though? I think that's what Judge St. Eve is getting at. If all ISIS said was, we hope as many people in the world as possible will support us, surely that's far too vague to count as a direction to go do anything.
Your Honor, that is very vague, but that is not what happened here, and that's not what the evidence shows. The directive from ISIS in this case was for supporters like the defendant, and they targeted supporters as a critical component of their official governmental media operation. And they said, we need you, supporters, to go online and terrorize our enemies. That's the word that came out of Inside 8. And specifically told supporters, if they close one account, open 3. If they close 3, open 30. And the defendant knew about that instruction. He quoted this video back to the online undercovers in the case. At one point, he discusses with OCE2 that Telegram had shut down a number of accounts because they were ISIS-related accounts and they were promoting terrorist content. And defendant says, if they close one, we make 2 more.
So is it fair, Ms. Wells, to say while articulating the line for all purposes, all future cases around what direction and coordination is very difficult. Here, the nexus between the message that ISIS put out, the call, and the defendant's response was very tight. Is that a fair takeaway in your view?
That is 100% accurate, Your Honor. There was a very tight connection between what the FTO ISIS told supporters to do, defendant's specific evidence showing that defendant heard that he talked about it, that he quoted it back to others, that he sent screenshots of that video to other people. And then, of course, the action that he took in response to that was to create a computer program that did what ISIS was asking supporters to do, but it did it at scale.
And then how about Mr. Herman makes a fair point that at all points in time, though, the defendant seems to take care to stay a step removed from ISIS.
Your Honor, I think there's 2 points there. One, the government disagrees with that characterization of the evidence. Second, the jury heard that argument and rejected it. To the extent that there were instances where the defendant did not follow through, say, on making a translation, that argument was made to the jury. There was also evidence that showed with regard to translations, for instance, defendant wanted to work with someone else who had more skills with Arabic, so there were reasonable inferences the jury could have drawn as to why that didn't happen. But what the evidence also showed is the defendant's persistent commitment to ISIS. He swore allegiance to the organization twice, which the Second Circuit has held is very good evidence of someone's formalization of their desire and intent to act at an FTO's direction.
But that's not what he's convicted. I mean, swearing allegiance alone surely falls within the realm of speech and viewpoint. And I mean, it seems to me this all gets down to the code, because he finds all kinds of ways to stall and put off and not do quite a few other things that would have made your case much easier, you know, whether it's, I don't know, just all kinds of activities. And it's just this code. And all the code does is replicate something from one place on Telegram to another.
A few things there, Your Honor. The code does more than that. There were actually 3 different permutations of the code that defendant shared with other people, and as our expert testified, they sort of grew in sophistication. The code, one, defendant, you know, he creates this computer program that could be used for neutral purposes. It doesn't have to be used for ISIS. He specifically wrote in his document that that was what he wanted it to be, that he wanted ISIS official media outlets to use it or to let him use it for them. But what that code did is it defeated spam filters. Those are technical limitations that Telegram had in place, and it used bots or automated sort of sub-programs to cycle through and evade that technical restriction that Telegram had in place. And then in the third and most sophisticated version of it that's written about in Heralds of the Internet, he adds a search function, which, as our expert testified, could be modified to do whatever the defendant wanted it to do. And then, of course, you have the Heralds of the Internet document itself, which is plainly on its face a teaching document that the defendant is sharing with people that he went out in the universe and found. This case is unusual in that these online undercovers didn't find the defendant. The defendant went out onto the Internet and contacted one person he believed was working for a brand that ISIS used to translate its official media into English, and another person that the defendant believed worked for an organization that distributed information about IEDs and explosives and toxins to would-be attackers. These are the people that the defendant found, that the defendant chose to share this information with. They weren't people who were bumping into the defendant at the government's request.
Right, but it's the link to ISIS. How important is it that he watched the Inside 8 video? I mean, he could have just picked up, you know, from general online information sources the fact that there's this thing out there called ISIS and what its activities are, and feel inspired and write this code and do all the rest of it. And do we have a proper case if ISIS didn't actually direct anything? He just volunteered, so to speak.
If there was no evidence in the case that ISIS had directed anything or that the defendant had not seen this video, that would be, I don't know that the government would be here with this case, Your Honor. Okay. However, to use Judge Scudder's term, that video shows this very tight connection. It closes that gap and takes us out of this concern about what is the limit of direction and control that Judge St. Eve raised and into a factual sufficiency issue. And here, the jury heard these arguments, they rejected it, the judge heard the same evidence, and on post-trial motions, rejected it. He found that the directive from ISIS was, quote, very clear. He also looked at the defendant's actions and said, quote, there was nothing independent about what the defendant was doing. So there's nothing new that's been raised here on this appeal. We have 3 issues, 2 that are squarely decided by the Supreme Court. 1, that services is not impermissibly vague, and 2, that the
But
First
that was an
Amendment...
as applied.
Yeah.
Yeah, the Supreme
Right,
Court
right.
decided it as applied in Humanitarian Law Project. This is as applied, not a general challenge to it. So I don't think we could say it's been resolved by the Supreme Court. They've certainly given a lot of guidance.
Well, here, Your Honor,
Well,
I
there
don't
are
think-
some services, in other words, that count, but you can't just call something a service and say, okay, we're done with that prong.
Yeah, indeed. Isn't the proper reading of Humanitarian Law Project isn't the court saying we are rejecting a pre-enforcement challenge to 2339B? That is unequivocal in the opinion. But to be certain, the court emphasizes there can be very, very difficult cases under this statute. And what the lower federal courts, us included, need to do is to take those cases one at a time and be very careful about trying to draw lines for all purposes and take them one at a time. And indeed, at the end of the opinion, the Chief Justice, on behalf of a majority, says there's going to be cases that are problematic and the convictions are void, and there's going to be cases that fall on the permissible side of the line. So
Your Honor-
isn't it all as applied?
Your Honor, the court certainly left open the possibility that there would be a case that required a court to revisit the standard that HLP set out. This case, in the government's view, is not that, because it said that services, while that was also as applied, it said that services, the context in which it's used in the statute confirms to the ordinary dictionary definition of services, and that a person of ordinary intelligence would understand that services that are provided to an FTO or at their direction or in coordination with them would not be protected.
But you still have to look at the different services at issue in the cases. That's the as applied part.
Well, here, Your Honor, I don't think it's a stretch to say that creating a computer program that you intend to direct to ISIS, in defendant's own words, he wants ISIS to use it, he wants them to allow him to use it for them if they don't do it themselves. And that he is directing something that he described as being the only person in the world who could do that, something that could accomplish in mere minutes what otherwise would have taken hours to do.
Because time is running out, I have one more question for you, please. You aren't contesting that creation of the computer program and dissemination of it is covered under the First Amendment, correct?
No, Your Honor. Standing alone, of course, a person can write a computer program, and that is.
But you're not contesting that's protected speech for purposes of this case?
No, Your Honor. I don't think. I think that part of what the defendant did here was conduct, but we're not disputing that some element of this, certainly the teaching of it to others, would constitute First Amendment conduct in the absence of what HLP says and the limitations of the material support statute. Thank you. If there's nothing further, we ask that the court affirm the conviction.
Okay. Ms. Wells, thanks to you. Mr. Herman, give you the time that you reserved on rebuttal.
Thank you, Judge. I had written a bunch of notes with HLP underscored and to clarify some things, but I think you did my job for me. But just to highlight it, it was an as-applied challenge. Chief Justice Roberts went out of his way multiple times to say there may be future cases that are more difficult, and we submit that this is that case. What HLP also did, and we think HLP fully supports us rather than closes the space off for future challenges, is it emphasized the need to provide the services or more training and expert assistance in that case to the FTO. And one thing that Ms. Wells said, which I don't think is reflected in the record, is that Mr. Osazinski was trying to get this program into the hands of ISIS, as opposed to carefully noting where the line was and communicating with non-FTO people.
Didn't he make statements to that effect, though? That he wanted to get it to ISIS and they were going to use it. I thought in the recordings he made some of those type of statements.
No, Your Honor, I don't think that's accurate, and I think also that the fact that he wouldn't even provide the screenshot to the CHS when the CHS said in, I believe it was October of 2019, if you give me the screenshot of the script, I will send it to the brothers in ISIS, and for 2 months he delayed on that. There was some debate back and forth about the use of the term brothers, and the brothers was not synonymous with ISIS when there was communication with non-FTO members.
What about all this training of OCE 4 that he seems to have undertaken? Hours, how to use this code, copy ISIS videos.
Judge, communications with a non-FTO member or non-FTO individual, in an instance where that individual is not saying, I am acting on behalf of ISIS, or I will give this to ISIS, you train me, I will train somebody in ISIS, is not the connection that HLP requires, where the services are provided to the FTO. And we touch on this in the middle argument, the vagueness argument, which is that providing services to a non-FTO member when there's not a connection to a back-end FTO is a vague application of the statute.
So you're basically saying, to go back to Judge Wood's initial question, that there's a problem here, there's a due process problem when the statute is trying to be applied through intermediaries of the designated organization.
Not intermediaries of the designated organization, fellow supporters who are non-FTO members. None of these individuals portray themselves to be intermediaries, unlike the typical sting operations where we say, somebody saying, I can help you travel to ISIS. I am, an agent of ISIS. Or
So you're saying the missing evidence is some evidence that ISIS delegated authority here to OCE 4. If ISIS had said, we're using OCE 4 and similar people to advance our mission in the world, and then OCE 4 is trained by Mr. Osadzinski, that would be enough to convict?
that would be a more difficult case from us from a sufficiency standpoint, and it's precisely why on multiple occasions the government, I think, tactically made a decision to see if he would provide something to ISIS, the translations and the screenshots. Judge Scudder, you asked about the direction. In the government's brief, Insight 8 specifically says, support your Khalifa on the digital front. And this is something that Mr. Osadzinski was doing even before the watching Insight 8. He told one of the operatives, I started this because I couldn't find them online. This was an independent project with independent advocacy, and we would ask that the conviction be vacated.
Okay. Very well. Mr. Herman, many thanks to you. Ms. Wells, thanks to you and your colleagues in the government. We'll take the appeal under advisement. Move to our second argument of the morning, case number 22-1179, Jacob Liquors versus the United States. Mr. Kelleher, nice to see you.
Good morning, Your Honors. Christopher Kelleher for the appellant. The parties have presented the court with 111 pages of briefing to read. These 111 pages can be distilled to a simple question. Do the words good faith mean anything? This simplicity belies the gravity of what is at stake.
Hold on. I'm sorry to interrupt you.
Certainly.
Can I just confirm, Mr. Simpson, I know you're remote. I just want to be sure that you can hear us in the courtroom.
You're on mute.
Yeah, unmute yourself.
Thank you for asking, Your Honor. I'm actually having a little bit of trouble hearing Mr. Kelleher. I'm going to try putting on headphones and hope that helps.
Okay, we're going to start from the top. That's my mistake.
All right,
I should have confirmed.
thank you, Your Honor.
Can you hear me with the headphones on?
Yes, I can.
Okay.
Why don't we see if Mr. Kelleher's coming through?
Yeah.
Okay. And can you hear me, Mr. Simpson?
Yes, I can hear a little better now.
Okay.
All right. Let's start anew.
Okay. Good morning, Your
Thank
Honors.
you.
Christopher Kelleher for the appellant. The parties have presented the court with 111 pages of briefing to read, and these 111 pages can be distilled to a simple question. Do the words good faith mean anything? This simplicity belies the gravity of what is at stake. An affirmance here, at the risk of sounding alarmist, would be the Fourth Amendment's obituary. And the reason being, if an officer can capitalize on the good faith exception despite misleading a magistrate, the warrant process would become a sham.
So how important do you think it is, Mr. Kelleher, that, at least certainly as I understand the law, the state court's view of this warrant and the evidence and whether there was, lawful search wasn't binding on the federal court later. The federal court was entitled to make its own decision. And so for whatever good, bad, or indifferent reasons the officer may have had, what we're talking about is withholding unnecessary information from the magistrate.
Certainly, Judge Wood. I would agree that the state court ruling is not binding. However, it's instructive. And this court, obviously, this panel noted in the direct appeal that it would inform the federal magistrate's decision. Another point being that the state court ruling is informative in the sense that this was a suppression. And the vast majority of suppression rulings go in the state's favor. So the fact that this was a suppression ruling in favor of the defendant would naturally pique the magistrate's interest in the fact that this was, a relative anomaly.
But Mr. Keller, how do you get around here? We're at habeas, and you know that's a big hill to climb.
Certainly.
There has to be a prejudice element that you can satisfy. And here, the state court suppressed the evidence on the basis of the initial confrontation and the initial stop, which we found in our prior opinion was constitutional. So if that had been disclosed to the district court, how could that have been, to the magistrate judge in issuing the warrant, how could that have been material to the court's determination when we found that the basis the state court suppressed on was wrong, that it was constitutional?
Certainly, Judge Steve, the problem here I think we have is we have a detention ruling by the state court finding the detention was illegal, and then we have a arrest ruling by this court that there was not probable cause for, I should say, the search. So basically, Mr. Lickers has prevailed on both stages of the initial detention and then the arrest, yet he still is convicted and serving his time.
Let's say the court had found that the agent intentionally withheld this suppression and should have disclosed it, but the information still has to be material. And how would the fact that the agent did not disclose that the state court suppressed the evidence on an incorrect basis, how could that be material?
Well, it's material in the sense that it negates, or at least is adverse to the probable cause determination. And I understand your position. It might not go directly.
It doesn't go to the probable cause in the affidavit to search the phone because we said that the basis that the state court suppressed on was wrong, that it was constitutional.
And Your Honor, I guess the best answer I can give is the failure to disclose, which was obviously we assert was intentional, it failed to disclose the entire picture of what was at stake here. And the fact that this situation, we had very little, basically no evidence. The affidavit was it. So if this was a situation where we had 4 other streams of evidence, we had a confidential informant, wiretaps, et cetera, my position would be much weaker. But the fact here is the affidavit was it. Agent Telesack knew that. He knew that the state court had rejected this case. They were on thin ice, and he had to do everything he could to save this warrant. And obviously, and I agree, Judge Wood, your question about the binding nature, it's certainly not binding, but that's not what the test is. The test is it material?
But that's my
But
question.
let me,
That's the question, is how is it material if we have already rejected the basis that the state court suppressed on?
Well, I guess I would say it is the fact that this was, your ruling was years later, in the sense that that wasn't before
So
the
not, it's
magistrate
not a
at
law
that
of the
time.
case question, it's a,
Right.
we ruled one way, assuming the
Right.
district court or the magistrate judge would have found
Correct.
the same way.
Correct.
So what I want to do is maybe change the focus a little bit and ask why, in light of what is a somewhat unusually confused record, you know, the state court looking at things certain ways and making certain decisions, faced with all of that, why should we find that Dalton performed ineffectively for purposes of the Sixth Amendment? Because actually that's where we are. We're not here revisiting whether there should have been a search or anything. We're here to see if he received the assistance of counsel to which he was entitled. And this was a messy situation, and we have things such as the fact that we have an objective reasonableness standard. We have lots of things that might have made a rational lawyer think, you know, that this just wasn't going to go anywhere.
Certainly, Judge Wood. The simple answer is we're here this morning. And the fact that we're here this morning because this court, to its credit, recognized this gaping hole in this case. And the
Well,
fact
we
that
recognize that there's something to talk about. I'll say. I'm not sure we can put that word on it.
certainly, but the fact that the court on its own, sua sponte, recognized this, and I know the court doesn't like to create more work for itself, but to its credit, recognized there was something wrong here. And obviously Mr. Lickers took that and ran with it in the habeas petition. But the other point would be that Mr. Dalton did challenge the affidavit on the probable cause grounds, and obviously did a good job with that. But the fact that he knew that he could challenge this warrant and does so, but then leaves out this critical.
How could it be deficient performance to challenge the evidence on the same basis that you were successful on in state court?
Well, because the falsity / reckless disregard for the truth, that would be just a stronger argument to make, I think, because, I mean, obviously on the cases that I've read, it's usually, for the most part, an open and shut case. The officer lied / withheld this critical information, versus when you delve into the probable cause morass, well, was this enough? That's a much more intricate, much more arduous argument to make. I mean, obviously you can make both, and that's what he should have, but he bypassed what I would say is the easier argument.
Can you, is my memory right? It's Daniel Dalton, right?
Yes.
Did Mr. Dalton, didn't he submit an affidavit or declaration in the district court?
Yes.
Okay. And didn't he say in that sworn submission that he basically addressed the point that Judge Wood was asking about and saying, the reason I never raised the issue, regarding the phone, essentially, for short, is because the state court rulings really didn't have anything to do with that. The state court rulings were about the propriety or lack thereof of ordering Mr. Lickers out of the car. They were about the delay with the K-9 unit coming that way. So he said, it just didn't dawn upon me. So that's what he submitted. So how can we say, if you take it back to where we're at, Strickland prong 1, IAC claim, how's it ineffective, constitutionally ineffective?
Well, because this ruling, this state court ruling, obviously cast this case in a bad light for the prosecution. The case was entirely rejected in the state court. So really any ammunition.
But for reasons having nothing to do with the phone, any state activity vis-a-vis the phone.
Yes, right? and that's correct. But the fact, I would just to reiterate that it cast this case in a bad light. The state court had rejected it entirely. And the fact that, and I believe the court implied this in its direct appeal, that later on there might be issues from that initial detention. So the detention, even if the federal court says, okay, the detention's okay, but there might be issues based on the evidence that was obtained from the initial detention. So in other words, that a problematic detention arguably problematic might have problems later on other subsequent issues, whether it's arrest, whether it's evidence. So again, that the initial stage of this case was problematic. Again, that should have tipped off Mr. Dalton that just include it and make that argument and see where it goes. Again, because this affidavit is it. And Mr. Dalton knew that. He knew that the affidavit was problematic, yet again, he did not follow that course of action. And the fact in his declaration, he says, well, it's not binding. Well, again, just as Judge Wood pointed out, binding is not the standard. If that was the standard, certainly we would lose. But the standard is not binding, it's not controlling, it's not, does this completely eradicate probable cause? The question is, does it negate probable cause? Is it adverse? Is it material? And again, adverse, and it may be a matter of semantics, but adverse, it's certainly adverse here when you have a state court throw the entire case out.
Can I just interject because time is getting short? This is a complicated area, how tainted warrants intersect with the Leon good faith standard. There seems to be a fairly deep conflict in the circuits on it. And I go back once again to the fact that we're here at part 1 of Strickland, and to ask Mr. Dalton to sort his way all the way through whether the warrant was tainted to begin with, whether it's even possible for the second officer, Telisek here, to rely on good faith when maybe he isn't giving as much information to the magistrate as he should have done. There are just different ways of looking at this, and for a lawyer to be tarred with ineffective performance is a little harsh, isn't it?
It's harsh, but if you look at the affidavit, and I concur with Your Honor that this area is a bit complex, but again, he was smart enough to recognize, okay, we can challenge this warrant, but again, he didn't take that second step. But again, the fact that the government, in its response brief, they wrote a 58-page response brief, and they've entirely surrendered on this issue of falsity and or reckless disregard for the truth. There was never an affidavit presented in the district court by Mr. Telisek, and that should speak volumes to this court and to the fact that this case is seriously troubling, recognizing the rare nature of habeas relief. I totally understand that, but if there are no further questions, I would reserve.
Yeah, you want to save your time?
Thank you.
Yeah, very well. Okay, Mr. Simpson, over to you. You got to take yourself off mute. Click. Yep, there you go.
I'm sorry, it's been a while since the pandemic. Good morning, Your Honors. May it please the court. I'm Scott Simpson on behalf of the United States. I'd like to start with something that I think really hasn't been addressed before. That is the fact that this court has already held on direct appeal that the good faith exception applies here. Of course, the only thing that's changed since then is that we now know the federal affiant was aware of the state court's ruling on Mr. Licker's motion to suppress. But that addition we submit does not change the appropriate outcome here, and we think this court's prior decision makes that clear.
So, Mr. Simpson, Mr. Simpson, this is Judge Wood. Here's the problem that I have. Yes, we did say in the direct appeal that the Leon...
Your Honor, I'm so sorry. I'm having trouble hearing.
Is this better?
Yes.
Okay, fine. We did say in the direct appeal that the Leon good faith doctrine applied. But there is something peculiar about saying that an officer who in bad faith does not supply all of the relevant information to the issuing magistrate judge is entitled to claim good faith, because there's the bad faith in the tainted warrant, and you never know what facts are going to be persuasive or not persuasive to the issuing magistrate judge or whoever, the state court judge. And so withholding the fact that these proceedings wound up washing out in the state court and the other aspects of this is actually quite troublesome. Why isn't that a good point? In fact, a compelling point that a competent lawyer should raise?
Your Honor, I think there are several points there, and I think first of all that we're not. It doesn't show bad faith that the agent left that fact out of the affidavit. To refer to something that petitioner's counsel said, I think it's not a falsity in the affidavit, and I think this court's prior decision reflects that it's not critical information,
Mr.
which I
Simpson,
think is
just
another.
step back from the facts of this case for a second. I think Judge Wood is asking a question that we really do need to grapple with, and that Mr. Kelleher has done a good job of framing up, and that is, forget these facts for a minute, okay? That is, do you think that Leon good faith protection should apply in a situation where, now I want you to hypothetically assume, forget these facts, hypothetically assume that an affiant materially or intentionally misrepresented a material fact. Should that affiant receive Leon protection?
But
Forget
he
the
didn't
facts of
actually-
this case.
I understand that, Your Honor, but the affiant didn't actually misrepresent a fact.
Hold on.
You're
hold-
still on the
Mr.
facts of this
Simpson,
case, yeah.
Forget this case. 100% forget this case. I'm asking you hypothetically, isn't it troubling and inconsistent with the foundation of Leon that if, as a factual matter, in some hypothetical case, an agent is found to have intentionally misrepresented a material fact, to then confer Leon protection?
I would agree, Your Honor, I'll get away from this case, as the court has asked me to, pretend like you have a case where a previous, where an agency, a state agency, previously sought a search warrant from a state court, and the state court denied that. And then later on, an FBI agent seeks a warrant in the same investigation to pursue the same prosecution. If the federal agent says to the federal court, the state court granted a search warrant in this case, yes, that would be very problematic. And
So,
I
Mr.
would
Simpson,
agree that
if I
that
could
would
just
be-
follow up on that a little bit, do you agree then, if the district court had found that there was a Franks violation, that Leon good faith could not save the day?
You're saying, Your Honor, if the federal court had found that there was a Franks violation?
Yes.
I think that would, I agree, that would also be very problematic.
That's why I think that's why you, with all respect, I think that's why you're mistaken with respect to the law of the case doctrine. Because all we could do on the direct appeal, or all we did, was take the record as it came to us. And the record as it came to us on the direct appeal, we had no reason to question the good faith premise. So now the good faith premise is being questioned in 2255, and there are questions coming up about whether, even if there was the omission of something intentionally or recklessly, whether that something is material. Right? I mean, that's the conversation we're having, but I don't see the law of the case as resolving anything. It's to say the law of the case resolves this appeal is to disregard the procedural posture of the two respective appeals.
But Your Honor, with respect, it seems to me, and I realize I'm talking to the panel that issued the first decision, although I recognize that's not necessarily relevant. It's the court's decision. But respectfully, it seems to us that the court's earlier decision reflects, for example, one sentence from the court's decision is, the good faith of the FBI agents can be shown without delving into the propriety of their reliance on the fruit of an unconstitutional search as found by the state court. In other words, the court was saying that we believe, the court was saying not following the better practice. And again, to go back, we recognize that the court said that it may have been relevant to the good faith determination. what happened with the state search warrant request. The court, we acknowledge the court said the better practice would have been to include that information. But we read the court's earlier decision as saying that not following that better practice in seeking a warrant does not equate to bad faith in seeking a warrant. There was no evidence that the FBI agent was hiding information. It was just that he did not put in that information. He didn't put in the fact either way how the state court acted in relation to the request for a warrant.
But in a given case, that could, I mean, just to say he just didn't put it in, if he looked at it and thought it was some devastating fact that would persuade the magistrate judge not to issue the warrant, he would just not put it in. But we have a different record now. That's the purpose of 2255s, and we tell people all the time, don't raise a Strickland claim on direct appeal because you're not going to have the right record to allow a sensible decision one way or the other on it. Now, that's just what Mr. Lickers has done. He's raised the 2255 collateral attack, and he has more information. In fact, it wasn't until you filed your brief in response to our questions that it became clear that this FBI agent knew all along what the state court had done. It's a little troubling.
Your Honor, I'll try to answer that question, but I do want to go ahead and move ahead to the ineffective assistance issue since my time is about half over. But we would submit that there's a difference between hiding, a difference between not stating information, a difference between, say you have a question, you have a factual question. Did X happen? What happened here is that the FBI agent simply didn't put in there what happened with the state warrant request. Again, if the FBI agent had said the state warrant was granted and there was no problem with it, that yes would be problematic. But simply not to put in information whose relevance, and I'll talk about this in a moment, whose relevance, and I think earlier questions by the court itself reflected that really what the state court did with the warrant really isn't material to what the federal court should do to it. Just the fact that the FBI agent did not answer that question, just simply left out the yes or no. You could say yes or no, and if he had said no, or if he had said yes, that the state warrant was granted and so forth, that'd be problematic.
Well, see, and that's what he did. He attaches the state search warrant as an exhibit. But that's half information, right? Makes the
I'm sorry, I
magistrate
didn't quite catch that.
Mr. Telesak attached the state search warrant as an exhibit to his affidavit.
Yes, he did.
So this isn't just I'm not saying anything one way or the other about what happened before. It's a half-truth.
Also, by attaching it, couldn't the court have inferred that it was actually granted at the state court if it was attached?
I can understand that, but just one more point, if I could, on the good faith question, and I was going to mention this as well in the ineffective assistance on the ineffective assistance issue. Just 2 days later, this very same FBI agent submitted a complaint affidavit to the very same federal district court judge, Chief Judge Darrow. And in that second affidavit, 2 days later, he did include the status of the state search warrant. So I think that, in addition to all that we've already talked about, I think that goes an additional distance to showing that he wasn't acting in bad faith. He just didn't include that fact. If he had been trying to hide something, surely he would have known that putting that fact in the second affidavit would certainly have invited the ire of the federal district court judge. But if I could move on to the ineffective assistance issues, Your Honors, as always under Strickland, we need to look at the situation as defense counsel saw it at the time. And what counsel saw is that the state court had resolved the motion to suppress based on its views regarding the outset of the encounter, that is, holding that Mr. Lickers was unlawfully detained. The state court, as we've already acknowledged, never reached the question of whether the state search warrant was supported by probable cause to search the devices. And in fact, this court, in its decision, as we've already referred to, disagreed with the state court's view on that unlawful detention issue. And the district judge, in fact, if you look at the district judge's order denying the 2255 motion, she expressly said that knowing about the state court suppression ruling would not have impacted her analysis on the motion to suppress in federal court. So for all these reasons that we've discussed, the state court's ruling was not relevant to the question before the federal court, that is, whether the warrant was supported by probable cause. We're also talking, we've talked already, I believe, in relation to petitioner's counsel's argument that these are separate court systems. No matter what the state court said, even if it had reached the warrant question, which it didn't, the state court's views were not binding on the federal court. And finally, referring to the different affidavits, because defense counsel were looking at the facts more closely in time than we are, we can look at the dates of the two affidavits and see that they're only 2 days apart. But Mr. Lickers' attorneys would have been very aware, because they were very close in time to the development of those facts. They would have been very aware that the FBI agent's search warrant affidavit preceded the complaint affidavit by only 2 days. And under those circumstances, we really can't expect Mr. Lickers' attorneys to think that omission made any difference. In summary, Your Honors, since the state suppression ruling was irrelevant, the decisions by Mr. Lickers' trial and appellate attorneys not to include that ruling in seeking suppression in federal court did not constitute deficient performance and did not prejudice the petitioner for the additional reasons that we've talked about in our briefing. So unless there are any further questions from the court, we'll ask the court to affirm.
Okay, very well. Mr. Simpson, Mr. Kelleher, back to you.
Thank you, Your Honors. I think what also gets lost in the mix here is the fact that the suppressed evidence from state court was used for the federal court warrant. In other words, a state court suppressed this evidence, and Telesac used that suppressed evidence without informing the magistrate that this evidence had been suppressed as the basis for the federal court warrant. And
so,
this
Mr. Kelleher, I thought I remembered, though, that at the 2255 stage, the district court rejected the idea that Telesac was not acting in good faith.
It did. The court
I thought
did.
this was a fact finding to which we owe some attention.
Yes, Your Honor, but the fact that in the original affidavit in the federal court for the federal magistrate, the affidavit from Mr. Telesac included, or I should say the warrant application included suppressed evidence, the video, the horrific video of a sexual assault.
Right, so I can just say, page 12 of the district court, she says, the court agrees with Attorney Dalton's assessment and for the same reason finds that Lickers cannot show prejudice even if the FBI agent knew about the state suppression hearing and even if the Seventh Circuit's decision left this issue unanswered. The court finds that the FBI agent acted in good faith in relying on the federal warrant. And then she goes on and explains why she's thinking that. So I'd just like your view on how much weight we should put on that finding.
Well, I would argue that it's either it might be a mixed question of law and fact, which would, different standard review de novo. But again, we respectfully and
Sure.
vigorously disagree with that assessment for the simple fact they were able to get affidavits from counsel, but they didn't get one from the agent. I mean, that should speak volumes. And I recognize my time is up, but again, just to point out, when this court gets a summary judgment decision, usually Your Honor, skip to the appendix. You look at what the district court did. Are you bound by what the district court did? No, you don't have it's a de novo review. You don't have to give them deference, but you still
Not
want
if
to
it's
look
a
and
factual
see.
determination.
Right,
It's
but if
clearly
there's
erroneous.
right, but if there are legal issues, Your Honors, look to see what the district court did, and it's not controlling, but it's good to see what the court did, and that would be the same here. The federal magistrate should have would want to know what the state court did, even though it's not bound. So, thank you for the additional time.
Mr. Kelleher, thanks to you. I see here you accepted the appointment to represent
Yes,
Mr. Lickers, correct? We very much appreciate that, your service to him and the court. Mr. Simpson, thanks to you here as well. I was remiss in the first argument, the United States versus Ozadzinski, to not recognize Mr. Herman, but I think he knows from the context of the full argument that we very much appreciate his advocacy in that appeal as well. So we'll take this one under advisement. We'll move to our third argument of the morning. The third case is a consolidation of two appeals, 22-2994 and 23-1461. The United States versus Sean Connolly and Mr. Yates, Christopher Yates. And we'll hear first from Ms. Wood. Good morning. Before you begin, let me just make sure, Mr. Simpson, can you hear us okay from the courtroom?
Yes, I can, Your Honor. Thank
Okay,
you.
and Ms. Wood, can you say something to test it from your end?
Sure. Good morning, Mr. Simpson.
I have a little trouble hearing counsel, but I definitely hear Your Honors very well.
Okay, so let me ask Ms. Wood to speak up as best she can, and we'll
Sure.
proceed. Mr. Simpson, if for some reason you can't hear, just wave your hand.
All right. Thank you very much, Your Honor.
Okay.
Good morning, Your Honors, and may it please the court. My name is Lisa Wood, and I represent Sean Connolly. This appeal raises two issues. First, whether the district court relied on unreliable evidence in calculating the total drug weight attributable to Mr. Connolly. And second, whether the district court erred in concluding that the total drug weight of the conspiracy was foreseeable to Mr. Connolly. Unless the court has questions, I plan to focus on the first issue, whether the court relied on unreliable evidence in determining drug weight.
Are you attacking anyone other than Reckheimer and Phelps?
Judge, I'm not attacking anyone else's statements. However, I don't think the other statements and the other evidence that the judge relied on in determining that Reckheimer and Phelps's statements were corroborated is actually corroborating. What the district court relied on were the controlled buys and seizures, which amounted to 141 grams and change of methamphetamine. But the problem with this was that there was no evidence that these seizures and these controlled buys were representative of the drug sale activity that occurred throughout the entire course of the conspiracy.
So is anything, maybe this is the other argument, I apologize, because what I'm worried about with the overall briefing here is whether anything less than testing every last gram of seized methamphetamine would suffice in this world where we have different sentencing for mixtures and for, kind of ice on up.
Judge, I believe that is Mr. Yates's argument.
Yeah, okay, I'll leave that alone then.
Here, I think the problem is we're talking about defense counsel advocated for, I believe, a level 32, which was, I believe, between 150 and 500 grams of methamphetamine. The government advocated for level 34, I believe, which was 500 grams to 1.5 kilograms. In the PSR placed the drug amount at about 700 grams. So we're not talking about a huge difference here.
But Mr. Connolly, I mean, is very much or at least there was evidence that Mr. Connolly was very much involved with this. He helps, hide methamphetamine from law enforcement. He has that phone call. He sometimes distributes from his house. I mean, there's a lot of evidence that someone could rely on to make all of this reasonably foreseeable to him.
I think putting aside whether or not, the entire weight of the conspiracy was reasonably foreseeable to him, if we look at Mr. Connolly's own actions, we're talking about controlled buys of drug amounts, I believe they're under 10 grams or at least under 20 grams of methamphetamine. So he personally is not distributing a huge...
But that doesn't matter, as you know, for purposes of the conspiracy and what he's held accountable for.
Correct, Judge.
And the
Correct.
district court here also relied on other co-conspirator statements, not just Phelps and the other one, Reckham, whose credibility you've challenged. So why wouldn't that be sufficient? I think it was Garland and Seelock, their testimony as well.
Correct. And I
Or
think
statements.
the problem with the other co-conspirator statements is that they essentially all talk about Christopher Yates and the amount of methamphetamine that he possessed because he was the one distributing to the others. They talked about Mr. Connolly to some extent as well. To some extent, yes.
And Yates is certainly a co-conspirator.
Agreed. And I think everyone agrees that, Yates was responsible, the amounts attributed to Yates were the bulk of the methamphetamine in this case. The problem with the other co-conspirator statements are that a lot of times they aren't tethered to a time period.
But this is a preponderance standard. And as
That's
you know, they
correct.
don't have to be specific that on this date I saw X amount being sold.
That's correct. But I think it's noteworthy that neither the district court nor the PSR relied on those other co-conspirator statements independently. The district court certainly said they corroborate Phelps and Reckhammer's statements, but they don't. But they didn't. She did not say, I'm attributing 50 grams of methamphetamine to person X's statement, and I think I see my time is up. If I can answer your question briefly, the fact that those statements are not tethered to a time period, there's a danger of double counting. There's a danger that they're vague. They don't contain a lot of details, and because of that, using them to corroborate the sort of more factually fulsome statements of Reckhammer and Phelps, whose credibility is questionable, I think was clear error.
Okay, we'll give you that minute on rebuttal.
I'm sorry?
We'll give you your minute on rebuttal.
Thank you, Judge. I appreciate it.
You're welcome. Okay, Ms. Masters, good morning.
Good morning, and may it please the court. Mr. Simpson, you can hear me? Okay, great. As the court's aware, I represent Christopher Yates. Every defendant has a due process right to be sentenced based upon accurate and reliable information, and that did not happen here for Christopher, who was sentenced based upon the assumption that the entirety of the 737 grams of meth was pure, and there was no evidence to back that up. The tested amounts all came from the same week. There was no testimony or other evidence providing any basis for extrapolating those results to make reliable assumptions about purity over time, because the conspiracy lasted 13 months and had a change of suppliers.
But Ms. Masters, this is not a case in which we just have one test of one buy and that's that. The district court imposes some tests on herself, and she says, well, there are 3 different transactions and they're for varying amounts, and so there's no reason to think, that in large quantity it's ice and in small quantities it's mixtures or it's pure or actual, as we call it. So she tests it in a number of different ways. It's just not as many ways as you want, and that's why I was alluding before. I'm very concerned about the idea that unless you test every last gram, you have to default back to the mixtures arrangement, and as opposed to what we seem to have acknowledged before, that you can have sampling. And she she does think that this is a valid sample.
So, Your Honor, the issue with what the district court did here is no one came to court and said any of these factors are reliable ones upon which to extrapolate for a conspiracy that lasts 13 months and has a change in supplier. So to your point, there could perhaps be a basis of extrapolation, that is the door that was left open by Carmel.
Right.
But what happened here is the government just came in and didn't present evidence on that. The government came in and said, we're not presenting evidence at sentencing, we're just making an argument, and the government's argument is one it now disavows on appeal. It agrees it was invalid. The argument that everybody knows in 2022 most of the meth circulating from cartels is pure. The conspiracy was in 2019. And so fundamentally, there was no evidence here presented by anybody. No witnesses came in and said, you can look at these factors, and from these factors, you can extrapolate. And it is
It
always
sounds
been,
like maybe you're backing off a little bit of your argument that everything needs to be tested, if you're agreeing that there could be a basis for extrapolation.
what we are agreeing to is the court left that door open in Carmel. And so we do think that the law should be, everything should be tested.
How would that
but-
be consistent with preponderance of the evidence?
Because there is no other way to determine purity over time. And the
But how
government
could you
hasn't come
even
in.
run a system that way? I mean, that would certainly preclude holding somebody responsible for drugs that you got testimony about at the sentencing phase, somebody coming in saying, oh, and we sold another 500 grams, when the actual drugs weren't there. It would mean that the only thing that you could rely on was actual physical possession of drugs that are actually tested.
Your Honor, I think this court has drawn distinctions, though, between purity and quantity, which is exactly what's happened in this case.
But you
we've
can't.
never-
But if you just have testimony about 500 grams, that's quantity. I understand. But your rule would require you to assume that those 500 grams were mixtures, because you can't test them.
And it wouldn't even be a rebuttable presumption, because based on your argument, you could never test those.
Well, Your Honor, our point is that really in this particular case, you don't even have to go that far and resolve that issue, because the government hasn't come up with evidence of an alternative theory. And unless and until it does, yes, it should all be tested, because that is the
So if you
plain
change
meaning.
this fact pattern, you don't have to go anywhere near as far as the point you made in your brief, I don't think. If you change this fact pattern and you say, Mr. Yates admitted, I know this is hypothetical, in a post-arrest statement, he admitted and stands by the admission that he only sold pure methamphetamine. He only sold and dealt in ice. It'd be very difficult to argue then at sentencing that the problem on purity was there's no testing of a more meaningful portion of the drug quantity, right?
I would agree with that. In
Right,
your
so it can't
hypothetical.
possibly be that testing is required. That's an extreme example, I know, but it can't possibly be that testing is required in all cases or complete testing in all cases. It's very much depends on the facts and circumstances.
I would go so far as to say in that particular circumstance you've given, yes, but for a variety of evidentiary issues having
No, I
to
know
do with
that's not
someone
this case.
admitting against interest.
But
So-
I think the reason you're getting that question is we have to be very careful about chiseling into stone a rule that says in methamphetamine cases 100% of the relevant quantity needs to be tested.
We've never said that in the drug
Right, why
realm.
would we ever say that?
Well, the reason you would say that is because the statute, because of the due process issues here, that defendants are entitled to be
Even in a
sentenced
case where
upon.
the next case involving John Doe, where Mr. Doe admits that he only and always dealt in pure methamphetamine.
I mean, Your Honor, I think I would have to concede that in that case, you might need to be.
Right, so we
making
have a
an
line
exception.
drawing, question, and you're making a fair point that, hey, all we have is 1 week here. It's a 13-month conspiracy. There was a supplier change. That's all you have to argue. You don't have to ask us to chisel anything into stone, do you?
I'm happy to concede I don't have to ask you to chisel anything into stone and to have you affirm because the government came in at sentencing and just made an argument without any evidence and it wasn't reliable, and they've
You don't mean
conceded
affirm,
it's
I
not
think.
reliable.
Well, we'll see. We'll give you a rebuttal time. Mr. Simpson, I'm sure, has a different perspective on it. Let's hear that.
Thank you.
Okay.
Thank you, Your Honors. May it please the court, I'm Scott Simpson on behalf of the United States. Look, I'll address Mr. Connolly's challenges first, since they relate to the amount of methamphetamine. Logically, address that first, and then I'll talk about Mr. Yates's challenge to the purity. There is certainly no clear error in the district court's finding that the conspiracy was responsible for at least the 500 grams of methamphetamine needed to reach base offense level 34. The district court, of course, only needs to estimate the amount of drugs handled by a conspiracy, and it's not an exact science, as this court has said. All the information here was consistent with at least exceeding the 500 gram threshold. That is, the statements of Phelps and Reckamer that the probation office relied on, the supporting statements of other co-conspirators, and the controlled purchase or seizure of about 1/3 of those 500 grams from 6 different members of the conspiracy over 10 different occasions. If the court looks, and I won't set out all of these numbers, but if the court looks at the statements by Gerald Guerin, Guarin, another conspirator, and Trenton Seelock, those statements, even considering them in a very conservative fashion, amount to way over 500 grams. So there's far from any basis for a definite and firm conviction that the district court got it wrong on the amount of methamphetamine. And by the same token, all of the evidence supports attributing at least that 500 gram threshold to Mr. Connolly. This was clearly a jointly undertaken criminal activity, and at least that amount was within the scope of the activity and reasonably foreseeable to Mr. Connolly. He helped plan the conspiracy's activities. He allowed conspiracy members to use his home to sell methamphetamine. He instructed conspiracy members on sending money to the leader, Christopher Yates, and he hid another member's methamphetamine when that person was arrested. This is an easy case on the amount and on attributing it to Mr. Connolly. So now on the purity of the conspiracy's methamphetamine, on this issue, the standard is even more favorable to the government. In the district court, the government has to establish the purity by at least a preponderance of the reliable evidence, and this court, of course, reviews that finding for an abuse of discretion.
All right,
And here
so Mr. Simpson, I'm looking at pages, depends which page numbers you want to use, but A31 through about A34 in the appendix to Mr. Yates's brief, which is where the district court, it's the part of the sentencing transcript where the district court concludes that these September 19, 2021 purchases are a representative sample of the 737 grams of ice. And what I can't find, there's certainly plenty of testing going on there, but what is it that justifies the inference that this 1 week in September was the same as the entire rest of the time for purposes of the type of, or the purity of the drug? It's all methamphetamine, for the purity. It seems like it just sort of comes out of thin air, or maybe what the government was arguing at the district court, that, everybody knows that people are turning to ice or even actual methamphetamine. But that's awfully touchy-feely. It doesn't seem like even some evidence that allows the inference.
Your Honor, there's several answers to that. Several different circumstances support the finding that those testings are representative of what the conspiracy handled. And I think the district judge relied on these circumstances in finding.
That's what I'm looking at in this segment, page A32. She says, I'm finding that it's accurate for the following reasons: not just one individual and one average quantity. There are 3 individuals, There are varying amounts, as low as 2.9 and as high as 110. She says they don't seem to be cutting it down. It was still pure at the 8-ball quantity, or approximately 2.9. So that's where she puts it out. But I don't see what fact in there tells you that this group was, specializing in particularly pure methamphetamine.
Your Honor, I get that's a finding, that's a holding for the court to make, whether that's representative.
What's the evidence that supports it? Judges don't just kind of get to come out here and say, well, I've decided to find this. It has to be evidence.
I understand that, Your Honor. Of course, all of those things that the district court lists there are evidence. Another fact is that the tested methamphetamine totaled about 28% of the 500 grams needed to reach base offense level 34. And I'm not sure the court referred to this just now, but I believe the district court also referred to the fact that the conspiracy used a single source of methamphetamine throughout.
But there was evidence that that's not correct. There was evidence that the supplier changed during the course of the conspiracy.
During the course, yes, Your Honor. What I was going to say is that the conspiracy used a single source during most of its existence. I believe the dates are that the conspiracy went from February of one year until January of the following year. It wasn't until December of that first year that the source changed, because the source was arrested. So for the vast majority of those months, they were using that single source.
So all of these tests come from 1 week on a 56 weeks. I come back to Judge Wood's question. What is the link that the purity from the 1 week can be the same, even by a preponderance of the evidence, for the other 55 weeks? There's no expert testimony. The usual things that we see and rely on aren't here.
Your Honor, and this gets into referring to the court's earlier decisions in Castaneda and Carnell, which I'll refer to. But another piece of evidence that we have here is that at least 2 members of the conspiracy told law enforcement authorities that the conspiracy's product was ice methamphetamine. Now, true, this court's decision in Carnell says that statements by co-conspirators are insufficient without more to establish purity, but here we have much more. Again, we
I
have
don't
all
see
of
the
these
much more. I guess that's what I'm trying to, and I think Judge Wood is trying to get that from you as well. What is the much more other than 3 tests during 1 week of a 56-week conspiracy and 2 members saying they sold ice?
Your Honor, I may have misspoken. I think the testing was done on 5 different seizures.
But all from the same week.
Correct. All from the same week.
Which suggests they came from the same group, the same distribution.
I'm sorry, from the same.
It suggests, since they were tested the same week, that it came from the same supply.
That's possible, Your Honor, but the district court didn't make any finding in that regard. And
Exactly.
Exactly. But Your Honor, since the seizures were made from 3 different members of the conspiracy, the different seizures could well have come from different deliveries that Mr. Yates made from his supplier.
If a defendant made that argument, the government would be criticizing it as pure speculation. I mean, there's nothing tells you. We know there are 3 individuals, and we know the time during which these tests took place, this 1 week in September. But there's just an absence of evidence about where these people got their drugs from.
That's correct, Your Honor. But I need to point out as well. Let me pull up the table that's in our brief. We have a table in our brief on pages 9 and 10 that talks about the different seizures and the amounts.
Right.
We can look at the fact that those Tested amounts were all seized within 1 week's time. But looking at the amounts of those seizures, one of them was 110 grams. One of them was 17 grams. And there's some smaller ones.
And the district court mentions that fact. I know.
So all of those add up. The amounts that were tested, even though admittedly they were seized in 1 week, all of that, because of those large size of the amounts, all of them add up to 28% of the 500 grams needed to reach base offense level 34. And we submit that besides the fact that you have that large percentage, 28%, all of these other facts add up to sufficient evidence of the purity. If I could, I noticed my time has expired. Could I just address for a moment the other side's argument that all of the testing, that all of the drugs should be tested?
Oh, you can, but I think Ms. Masters backed off that. But just be,
Okay.
if you have a brief comment to make, go ahead.
That certainly cannot be the law. That would limit a finding of ice or actual methamphetamine only to seized drugs and controlled purchases. And I think the court recognizes that.
Mr. Simpson, before we let you go, can I ask a question? How do you know that the source changed? What are you relying upon to say the source changed in December of 2019? I don't know that it makes much difference, but where's that at in the record? I couldn't figure out when the source changed. In fact, we looked in the record, and we couldn't figure out much about the source. There was a source, but then the source changed.
Your Honor, I know it's in there, and I wish I could find it very quickly.
All right. Well, if you find it and want to send us a letter, you can. I'm going to ask Ms. Masters the same question.
Certainly, I will do that, Your Honor. That's
Okay.
a very good question. I will do that. So, Your Honor, for all these reasons, we would urge the court to affirm in all respects. Thank you.
Mr. Simpson, thanks to you. Ms. Wood, we'll give you a minute, and then Ms. Masters will give you the same.
Thank you, Judge. I just want to point out, that Mr. Connolly's situation is similar to the situation this court looked at in United States versus Beller, where it was clear that the scope of the defendant's drug dealings extended beyond the amount he personally distributed, or even perhaps beyond the amount required for the mandatory minimum finding. But in that case, the court held that the fact that other drug sales were made did not corroborate the specific estimates of drug quantity provided by either of the two unreliable statements in that case. And I think the same is true here. The fact that there may have been, or there were, sales beyond the 50 gram, and I think, we would admit beyond 50 grams or perhaps even beyond 150 grams of methamphetamine does not corroborate a finding that the sales also exceeded beyond 500 grams. And so for that reason and for all the other reasons, we would ask that the court reverse. Thank you.
Thanks to you.
Your Honor, I'm going to begin with the answer to your question, Judge Scudder, about when the supplier changed. The only reference in the PSR is found on paragraph 28, and it's an interview. It's also cited in page 4 of our brief. An interview with one of the co-defendants who said that on December 11th of 2019, Christopher had informed her that his supplier had recently gotten arrested.
Okay, thank you.
So, and I want to just address briefly the issue about the percentages that Mr. Simpson raises, because he's talking about the tested amounts represent 28% to get to the 500 for the sentencing level, but of course, that doesn't give you anything about extrapolating to get up to 500, which is the whole issue here. There's no evidence. The government just simply didn't put on a case here, and that's why we're asking, similar to Gibbs, similar to Noble, for a limited remand to just be sentenced and not a do-over, because they just didn't put on a case. And it's always been the law that the government has to come in with evidence. to support its theory and to support the results, and it didn't do that here.
What would be competent evidence in your opinion? Excuse me if I could just ask the one question. Would it be enough if, I mean, aside from the admission hypothetical that Judge Scudder has posed, suppose the government came in from evidence of users of this methamphetamine over the year, and somebody testifies, I got the best ice I've ever had from the Yates conspiracy, or they say something like that. In other words, could anecdotal evidence supply this gap as in addition to actual chemistry lab testing?
So, Your Honor, to be frank, I think that's really the point is of our argument is the government has to come in with something. If they want to come in with that,
I understand. I'm just trying to figure out how realistic a scenario we are being asked to consider.
I think it's realistic for sure if we look at cases like that we cited, like Houston and like Din case, to come in and say, here's a theory of extrapolation. And the point I would make to Your Honor's question is the government has not come in and said there is no theory of extrapolation. What they did is they just came in and said, well, you can all just assume that it comes from the Mexicans, and the Mexicans all are producing pure meth. I mean, if they had some reason to back that up, then put it in the record, and then the court can decide these bigger questions.
Would you agree if an expert came in and said that might be enough to satisfy the preponderance? That this all came directly from Mexico. I've been involved in reviewing drug trade cases, and everything I have seen coming from this place in Mexico is 100% pure.
What I would agree at this point is that the government, if the government came in and did that and was willing to stand up on appeal and defend it, we would have a really different situation than the government putting on no evidence. And they just didn't do that, right? They didn't put on a case. I think your question probably gets at all of it, the hypothetical possibilities here, and that would be for the government to establish a record on and come up on appeal and defend it. So for the reasons set forth in our brief and those here today, we'd ask for a really limited remand in which only the tested amounts are considered pure and the bulk of the remaining 737 is considered a mixture. Thank you.
Ms. Masters, thanks to you. Ms. Wood, thanks to you. If I understand correctly, you both took the case on appointment from the court. We very much appreciate that as your part of service to the court and to your clients. Mr. Simpson, as always, thanks to you and the government. We'll take these two appeals under advisement. We'll move to our fourth argument of the morning. Okay, it's in appeal number 23-14-15. Gel Lab Cosmetics versus Waihi Iobo Cosmetics. Ms. Yu, good morning.
Good morning, Your Honors. May it please the Court. This is Tian Yuzhu appearing on behalf of Appellant G-Lab Cosmetics, LLC. This case involves G-Lab Cosmetics, LLC, a U.S. company suing 6 Chinese defendants, 3 individual defendants, 3 corporate defendants for trade secret misappropriation.
Ms. Chu, before we go too far down the road, can you tell me, please, the status of the New Jersey litigation and whether or not any of the issues have been resolved there?
The discovery has been extended. No discovery has been done yet. This is the status of the New Jersey case.
No discovery's been done yet?
Exactly, Your Honor. At the heart of this case is the misappropriation of G-Lab's trade secret, a violation that undermines the very foundation of fair competition and innovation.
But is that the heart of the case, or is the heart of the case a prior question, whether G-Lab itself owns these trade secrets? Because it's not stealing them from itself if it does. It seems to me this is one of those that if the result in the New Jersey case goes in one direction, this is a very easy case. And that's all. There's really nothing left to it. If it goes in the other direction, if the understanding of corporate ownership is as you suggest it is, then there's going to be more work to do. But the central position of the New Jersey litigation, I think, is hard to dispute.
Your Honor, from my understanding, even if one of the defendants, Albo, wrongly would be the 80% owner and the controlling ownership of G-Lab Cosmetics LLC, it doesn't mean that those defendants, Albo and the other conspiracy defendants in this case, did not steal any trade secret from G-Lab.
Explain what you
But,
mean.
and wouldn't it control, if they own 80% of Gel Labs, then wouldn't they be the ones controlling whether or not to bring this lawsuit in the first instance? There might still be trade secret issues, but if it's Gel Lab that's claiming the trade secrets and they own 80% of Gel Lab, they get to determine whether or not to bring the lawsuit.
Your Honor, under the New Jersey revised statute 42 2C68, a member may maintain a derivative action to enforce the right of the limited liability company. So as our client is also a member of the G-Lab Cosmetics LLC, our client does also have the right to maintain this action.
So you're essentially saying that this is, what then, a derivative action under a corporate law theory of unfaithful acts toward the business association?
Your Honor, let me correct my prior statement. My understanding and my position is that even if the Albo, one of the defendants, even if in the unlikely event it's going to be found at 80% owner, but this case, whoever retained us to file this lawsuit can also maintain this lawsuit.
What is this, when you say this lawsuit, you're talking about the federal court lawsuit?
Yes, Your Honor.
In your view, is the lawsuit that was filed in the federal district court a derivative claim brought under the federal trade secret statute? Or what is it?
It's a direct action.
Okay, okay, it's a direct action, right? So if it's a direct action, don't you run into the question
Right.
that Judge St. Eve is acting? In other words, those that control Gel Lab can make a controlling decision, can they not, on whether they want to pursue a direct action or whether they don't?
But that is right, Your Honor. They can make that decision, but the other members can still bring a derivative
But then
action.
it's not a direct action anymore. I
Right.
think you're not.
That would be
seeing
a
the
second,
difference.
in some other lawsuit. Maybe it's in New Jersey or in federal, somewhere else, but
But we are here, and there is a lawsuit.
But it's a direct lawsuit. I think it's a direct lawsuit, and I think even you would agree if the court in New Jersey determines that the defendants own 80% of Gel Lab, then that direct action can no longer stand. Maybe there's a derivative, but the direct action can no longer stand. Do you agree with that?
It is possible, Your Honor.
Okay, that's the concern.
well, that's I think why Judge Wood started where she did. So if the outcome in the New Jersey case is that, I know that's not your wish, but let's suppose for discussion purposes that that's what happens. Wouldn't those that are determined to be the 80% direct owner, they would direct dismissal, would they not, of the federal, presumably the federal court trade secret litigation? And the reason is because they could issue a controlling directive.
And then if there were some later derivative litigation, that yet to be determined, we don't need to get into things that are too hypothetical. And I want to just focus you, since time is slipping away. The district court here actually took a fairly modest approach to this. He looks at the Colorado River criteria. He asks, how do we, in the interest of wise judicial administration and the other factors that you're supposed to think of with Colorado River, he asks, how am I supposed to treat this parallel New Jersey litigation? And he concludes that these factors, none of which is dispositive, there could be other factors, like all these multi-factor tests. He concludes that the wise approach is not to dismiss, is to stay the federal action. So if the New Jersey result is the one that you're hoping for, this case hasn't died. This case is on ice right now, and it could come back. And I think we're looking at this as an abuse of discretion kind of review, and it's hard for me to see what discretion is being abused here.
Oh, thank you, Your Honor, for bringing this up. From my view, this court has previously held the record. This court has required that the record in the district court demonstrate that the decision whether to abstain or proceed with the case, carefully weighing the factors.
Right, and you're talking about the Hawan case, which was quite different from this. The district judge gives a pretty good explanation here for why he's thinking about that. We don't have a page limit on what the district judges are supposed to do. And again, not every factor is probably ever going to point in the same direction, but he sees a great, heavy balance in favor of this stay, not a dismissal.
Your Honor, from my understanding, this court, combined with the other holdings from this court, the district court should have considered all 10 factors. But in this case, the district court did not consider all 10 factors.
But there's no reason to believe that anything he didn't discuss in great detail would have leaned in the other direction. I think he does discuss most of the factors. It just depends whether you are using the exact same vocabulary as Colorado River or maybe synonyms.
Understood, Your Honor. I would like to reserve my time for rebuttal.
Yeah, okay, very well.
Thank
Yep,
you.
you can do so.
Thank you, Your Honor.
Mr. Bruce, good morning.
Good morning. I'm William Bruce, counsel for appellees, whom I will refer to as Zuhai. I want to make 3 points regarding why the case is parallel and the district court did not abuse its discretion. And before I do that, the cases we primarily rely on is the 2014 Freed opinion and the 2021 Laugren opinion, and they discuss the issue that's in this case regarding defensive, non-exclusive or non-mutual defensive collateral estoppel being sufficient to find the cases are parallel. And as the court recognized, the threshold issue is being directly and actively decided in the New Jersey State Court, and that is the controlling ownership of GLAM.
Is it your understanding also that court has kind of stalled on discovery or has chosen not to move forward with discovery yet?
No, Your Honor, that's not my understanding. There has been some discovery, and there's been a lot of discovery disputes. The original date was August 2022. At the time of the stay, all discovery was scheduled to end in April 2023. It's been extended to December 29th, and I understand that there are pending motions to compel. One side hadn't produced enough documents to allow for depositions. So the fact that there has been so much discovery dispute, I think, also weighs in favor of abstention because you get the risk of piecemeal litigation through that.
Correct me if I'm wrong here, and Ms. Ju can as well. It seems to me there has to have been some evidentiary dimension to the proceedings in New Jersey because the state judge in New Jersey put the entity Gel Lab under like a monitorship, basically.
Receiver.
Yeah, like a receiver or monitorship, right? So.
And the district court made the finding, too, I
Yeah.
believe, that discovery was near completion.
I
It would-
thought that too.
Yeah.
Yeah, it was scheduled to be near completion, and in addition to that, it has decided partial summary judgment from one of the defendants in that case, an owner of GLAB who isn't in this case, and it has appointed the special temporary fiscal agent. Recently,
Right, and is it fair to say it seemed very odd that there's no evidence accompanying those orders? They certainly didn't do it sua sponte. The New Jersey court?
no, it was a
There's
consent.
evidence.
There was a consent from both parties consented to appointing a special fiscal agent to monitor and audit GLAB.
Okay, all right.
And so, I think in addition to the cases being parallel, as you have discussed, if the controlling ownership is decided in favor of our client Suhai, we would voluntarily dismiss this case. In addition to that, they wouldn't have liability under the federal DTSA Act for misappropriating their trade secrets, and that would knock out the case from federal court and lose subject matter jurisdiction.
So is there some remaining claim? Does New Jersey recognize claims by minority owners for looting the company or, other sorts of problems?
Yes, Judge. I think we derivative action, breach of fiduciary duty, breach of contract, we have state law claim in this case because these offenders are all foreign.
You can't bring a derivative federal action, though, for trade secrets. That doesn't exist.
Exactly, Your Honor, and so that's why a finding on a two independent basis for parallel cases. One, if Suhai is a controlling owner, they would dismiss the case, the direct action. Number two, they wouldn't be liable under the federal DTSA claim, and so you wouldn't have federal jurisdiction. Regarding the abuse of discretion analysis, the court succinctly but reasonably addressed almost all of the factors and did them together regarding the progress of the case. The state case was filed 20 months before this case, and the risk of piecemeal litigation because of that. Grouped them together in paragraphs, but this litigation is, in federal court, is the result of the litigation choices of Mr. Chen, who the court found was behind this lawsuit and who presumably would be bringing the derivative claim if there is one. And he decided to have the ownership issue decided by the New Jersey state court, and despite that issue being undecided, he still caused GLAB to file this federal lawsuit in Illinois that's totally unconnected.
What happens if the New Jersey court finds that he is the primary owner?
Then he can resume the
stay will be lifted?
Yes, the stay will be lifted.
And that's the prudence of the observation that Judge Wood remarked upon, right? That the district court here didn't dismiss, it stayed.
Yes, Your Honor.
Stayed because you have a threshold issue of who owns the LLC, who's the controlling owner, and an owner is not going to steal a trade secret from themselves. It's an incoherent theory. So let's let that get sorted out in state court, and we'll figure out whether we have to lift the bookmark or not in federal court.
Yes, Your Honor.
That kind of flexibility seems inherent in the underpinnings of our case, especially the most recent opinion, Loughran.
Yes, Your Honor.
I mean,
yes, and I agree with that. And the last point I would make is I think in addition to the court's reasoning on why the cases risk piecemeal litigation, also agree with the reasoning on why the New Jersey court is better positioned to decide this threshold issue given the progress of the case, the summary judgment, special fiscal agent, discovery disputes. And so if the court doesn't have any more questions, I'll yield the rest of my time.
okay, Mr. Bruce, thanks very much.
Thank you.
Appreciate it. Ms. Jew, you're welcome to advance a rebuttal argument here.
Thank you, Your Honor. Because appellant's arguments is that, well, we do believe, because the lower court should not abstain from adjudicating the real issue at hand, because the protection of the trade secret and because the necessity of preserving the evidence of the trade secret misappropriation. And that's why we filed this appeal, and we would like this court to direct the district court to resume this case.
Okay.
Thank you, Your Honor.
Thank you very much, Ms. Jew, to you, Mr. Bruce, to you and your colleague. We'll take the appeal under advisement. That brings us to our fifth and final argument of the morning in appeal number 23-1678, Antosh and Lashley versus the Village of Mount Pleasant. Mr. Olson, yep, good morning.
Good morning, Your Honors. May it please the court. My name is, oh, I'm sorry. Was I supposed to wait for a second?
Yeah, you can go right ahead.
Oh, I can go ahead. My name is Eric Wilson, and I represent the appellants in this matter. This matter stems from an eminent domain styled taking, which was initially appeared to be for road purposes, but then as part of the state litigation unfolded, it became apparent that in fact the taking was for the Foxconn project.
Mr.
So,
Olson, I
Mr.
have a-
Olson, can I? Whew, I mean, maybe it's the same question. As I read through this rather voluminous file, I kept having trouble seeing road purposes and the Foxconn project as two completely different things. The reason they were interested in improving that particular section of road may well have been inspired by not just the hope for the Foxconn project, but the hope for the entire tax increment district development. They were seeing this as something. And they indeed did change the roads. So I don't know where under Wisconsin eminent domain the motivation for a road project makes any difference. Roads are public goods. These were available to the public. They're there now. Wisconsin has better roads in this area. So explain to me why this dichotomy that you see is there.
Imagine, for example, if a corrupt mayor of a city caused a 40-acre parcel to be condemned for his son so that his son could build a warehouse on it.
But we don't have that. We have the condemnation of the Antosh's, I'll call it that, the Antosh-Lashley parcel. And the road intersection is indeed improved. Now, if it's a corrupt mayor who wants a really nice road there, actually I can think of historical examples of people having bridges built or exits on highways or, you know, all kinds of places where politically influential people affect the timing and scope of projects, but it's a public good in the end. It's just a better road now.
If we look at what Justice Kennedy said in the Kelo case, which is cited on page 17
Yeah,
of
we're
our...
familiar with Kelo, which, by the way, does uphold this sort of public development use of the eminent domain power.
True, Your Honor, but it upholds it without a blank check. On 17 of our brief, if I may read, Justice Kennedy voted to uphold the eminent domain use. However, his opinion was hardly a blank check. Kennedy explained that while a rational basis standard of review applied, transfers intended to confer benefits on particular favored private entities with only incidental or pretextual public benefits are barred under the Fifth Amendment. And
Mr. Olson, can I
Yes.
try to, I'm going to ask you what I think is the same question.
Yes, sir.
Okay. It goes to this dichotomy. The thing that throws me off about your brief, and why don't you tell me it doesn't? That's what I'm interested in. Is you say, well, we had not a clue. We had no idea that this road project had anything to do with Foxconn. And what I say to myself is, how can that possibly be the case factually? Because of the notice that your clients received, the development of the road, it seems to me, is part of the broader Foxconn development project, and they were told that from the beginning in the appraisal that was provided, in the appraisal correspondence that was provided. So am I reacting the wrong way to your brief, which seems like what you were trying to express was my clients were shocked, they were floored to learn that this had anything to do with Foxconn?
That's true, Your Honor, though it may be in Wisconsin, we have a framework for eminent domain law where people who are facing eminent domain are entitled to bring two different types of lawsuits.
Right, no,
which
I
provide
don't
some
think
of
you're
these.
answering Judge Scudder's
Right.
question.
I'm
though.
asking you as a
Right.
factual
There's
matter.
this
How
June 3, 2019 letter that says, written to them, that says these roadways are being improved to allow for the construction of an industrial development that is commonly known as the Foxconn development. And that's not the last time Foxconn is mentioned. They And so when the condemnation happens, when the village records this award of damages, which I gather is kind of the pivotal moment, they choose not to, actually earlier, they choose not to bring the right to take sort of action, which I see under the structure of Wisconsin law as a waiver on their part of whatever arguments you might have made, and they agree that they're just going to follow the other sort of action, the amount of compensation action. And so now to try to revive the first one in federal court seems to me that it's just too late. They waived their right to do that.
No, I don't, well, first of all, let me explain one thing. When we go to the map of the taking, which we see on page.
No, they're here and there.
You know where this map is.
We got it.
Okay.
We've seen
And
the map.
so when we look at what was taken, the condemning authority took only the area within the blue lines.
Yeah.
If they had also taken the chunk laying to the northwest, we would have immediately filed a right to take action, just like we did in all the cases that were lumped in with the Jensen case, which came before this court. Because the condemning authority did not take that chunk, we thought, okay, this is not something where we are going to be able to win a right to take action because they served a jurisdictional offer under 32.05 sub 5, they recorded an award of damages under 32.05 sub 5, and they carefully confined their taking only to the area within the blue lines.
Right, so they
and
just
did
take
not
what they
take
need for the road.
the
They
chunk
leave
to the
the, you know,
northwest.
if you wanted to do other things with the rest of that land, that was up to you.
Yeah, so what's troubling to me is what you're doing, it's helpful. You're describing the litigation decisions that you made, right, and why you made them. But I am still stuck at the very beginning of how could your clients have reasonably thought it has nothing to do with Foxconn? Given the core, I don't know why they didn't take the other blue part. I have no idea. Maybe you know, but to think that it has, the taking has nothing to do with Foxconn is what I keep stumbling on.
And let me just add to that fact, if I could please, what the district court relied on, that the map for the rezoning that you relied on in the other case that shows your client's property, and there specifically says Foxconn project properties map.
Right, and it included the chunk to the northwest. So let me try to make an argument. If at the time that that jurisdictional offer had come in, we had filed two lawsuits, a right to take lawsuit and a compensation lawsuit, we would have been perfectly fine doing that. That's what we did in the other case. And those two cases would have continued on through the court system. So the only question becomes, is it too late to file this one, this right to take styled lawsuit at this point in time?
Well, and under Wisconsin law, it seems pretty clear it is.
It would be too late to file it under 32.05 sub 5. It may very well not have been too late to file it under Article 1, Section 13. However, we never got to that point because this was on a motion to
But
dismiss.
what troubled
that
the
this came
district court was you were, I think, correct me if I'm wrong, a couple of days away from trial, right?
When
Was
the
it-
federal action was
Yeah.
filed.
Yeah. A couple,
Yeah.
not weeks, a couple of days. There was
Yeah.
an adverse ruling
Right.
in the state litigation
About the project influence rule, right?
about the project influence rule, right? And you see the adverse ruling, and then you come over in 1983 into federal court.
Right.
So the reason I'm observing that is when you combine two facts in my mind, the whole world knew about Foxconn, number one, and definitely the people that live at an intersection near Foxconn. I can't imagine a world where they don't know what it is. And number two, on the brink of the trial, you come over to federal court, it looks like under that 10th Colorado River factor, that it's very hard to call the district court's discretion, an abuse.
Under Colorado River, I believe that the cases are clearly not parallel because under the Wisconsin framework, you're always allowed to have a right to take and a compensation case that proceed independently of one another. There's a question whether it was time barred and how 1983 32.05 sub 5 and Article 1, Section 13 of the Wisconsin Constitution interact. I will make this candid representation to in terms of time barring. We offered to proceed with the trial, with the other side only waiving that by proceeding, that they would not use our proceeding with the trial as a waiver against us in the federal court case, that they would allow that to rise and fall on its own merits, whatever it may be, without saying that because we proceeded with the trial, we had waived something. They would not allow us to do that. So I believe that we did the best we could under the circumstances, and we were accused of some pretty serious gamesmanship. I guarantee you it was not that. I thought at the beginning we didn't have a chance of winning a right to take case because they styled it as a road taking and they only took the area in the blue lines. When they convinced the circuit court that it was part and parcel of the Foxconn project, which we argued against, we said, no, it's not part of the Foxconn project, and they argued for project influence purposes that it was. And then they ultimately convinced that district court that it was part and parcel of the Foxconn project. Then I believe judicial estoppel applies. And we showed that flipping back and forth. So I think that there's an argument that it was not until we had the knowledge that the state court would be convinced of that argument. That,
Yeah, I think we understand. We're going to give you a little bit of time on rebuttal. Let's shift over and hear from the village's counsel.
Yeah, thank you very much,
Yeah.
Your Honors.
Okay.
May it please the court, my name is Chris Avalone. I represent the Village of Mount Pleasant, the Village of Mount Pleasant Redevelopment Authority, and Mr. DeGroot. Your honors have it spot on. This case is about a road, and it's always been about a road. When the village acquired the land in 2019, they stated it was for a road because that's what was ultimately built on that. And it's now a public road. It's not, there's no allegation here that only Foxconn is able to use this road or that some other private party receives the only benefit of this road. There is a public benefit here.
So, Mr. Avalon, maybe you can answer the question Mr. Olson was putting on the table. If the only thing that the present Wisconsin litigation is competent to address is the amount of compensation that these people are due for the land that was taken, I'll say for the road, then explain to me why that Wisconsin litigation is parallel to their effort to bring a broad-based takings action under 1983 pursuant to federal constitutional law.
Sure, Your Honor. This circuit does not require perfect symmetry for two cases to be parallel. Rather, it requires there to be substantially the same parties, substantially the same issues, and a significant likelihood that a resolution of the state courts will be dispositive in the federal case. And all of those factors are present here. The plaintiffs are the same in both cases. The primary defendant, the village, is the same in both cases. And the additional defendants here, they don't have interests that diverge such that it would make the parties different. With regard to the issues, the basic facts and issues in both cases are the same. It's how the village acquired this property to build a road. And it is true that the state...
And whether it was to build a road or whether it was for Foxconn's private use, I suppose, to...
Yeah, we'll
at least as I understand it, that's their argument.
Yes, but in our view, that doesn't make a difference under Kelo. But I'll get to that later. But to respond directly to the parallel issues, it's our position that when the village acquired the road, the appellants could have filed a right to take action. If they would have filed that right to take action, that action takes precedence over all other matters then ongoing in the circuit court. And that serves the village's interest in finality in eminent domain procedures. And additionally, it's apparent that the relief they seek in the state court is exactly what they seek in this court. They want more money in the state court. They think they're entitled to 5 to 8 times the amount they receive for their land per acre compared to what other individuals within the project area received. And if you look at their equal protection claim in this case, they're essentially asking for the same relief. They want 5 to 8 times they want the project influence rule to not apply, and they want to receive a greater sum for their property. And Laughlin and Freed also established that as this court reviews Colorado River cases, it can also consider what choices the appellant made in the state court litigation and how that affects parallelism in this case, because they had their right to take under state law. And at the time, they also could have went directly to federal court because Nick was decided a few months prior to this taking.
Yes, Nick was already on the books when this happened, so they were not disadvantaged by Williamson at all.
No, that's correct, Your Honor. And because these two issues are because the two cases are parallel in our opinion, the Judge Ludwig did not abuse his discretion. He writes an 11-page opinion that marches through the various factors, and just to briefly discuss a few of those factors, under Factor 1, this case involves property. And by operation of state law, fee title in this property has already transferred over to the village, and then it went on to the county because now it's a county road. Under Factor 3, the appellants have created piecemeal litigation by now filing this federal case less than a week before they were to try their just compensation case in state court. And also under Factor 4, the relative progress of each of the cases, the state court case was way further ahead than the federal case. The federal case didn't make it past a motion to dismiss. Nor is this a situation where there's no state remedy for them. They had the right to file a right to take. And this is true whether because the village proceeded with the taking under 3205, but also the subtext of Mr. Olson's argument is that, well, if the village would have proceeded under 3206, things would look differently. They wouldn't. They would have still had to file a right to take action in 40 days, and the project influence rule would still apply.
The difference between those two being the one is for roads and sewers and the other is for everything else. Is that right?
Yes, Your Honor. And last, as the court already seized on, this, in our opinion, this litigation is vexatious and contrived. There's no reason that the appellants had to wait until a few days before trial to file their federal action. In fact, if the court were to believe them that they were shocked that the road taking was associated with TID number 5 and the Foxconn development, then they would have filed their federal lawsuit in November of 2021 when the village filed the motion in limine seeking application of the project influence rule. Or they could have filed it in early January when the court agreed and applied the project influence rule. Instead, they waited till trial was less than a week later, and then they filed the federal action. So for these reasons, we submit that these two cases are parallel under Colorado River. And if the court disagrees and intends to review the case on the merits, we submit that the court should still affirm because the amended complaint does not state a claim for relief. As the court's aware, it asserts a variety of constitutional claims, and each of these fails. If we start with the private taking claim under the Fifth Amendment, the court can't ignore that the village acquired the land for a road, it built the land for a road, and the use of eminent domain to acquire land for a road has a legitimate public purpose. And even if this court says, no, we're going to look at this as the entire Foxconn project, then it's our opinion that this easily passes muster under Kelo. It was preceded by the legislative determination of both the state legislature with 2017 WIS 58, which authorized a TID for a high-tech development area, and also the village board, and which was preceded also by numerous public hearings. And we just don't think.
Can I ask you a question about that? The legislative activity that the Wisconsin General Assembly undertook, as I understand it, affected about close to 3,000, about 2,900 acres of property.
Yes, Your Honor.
And the project was going to be, $737 million. Is there any question that the Antosh and Lashley property is within the 2,900 acres?
No, it falls right on the map that was provided to all landowners within the project.
Yeah, okay.
Returning to Kilo, we think that the project was intended to and did provide a significant public benefit via jobs, increased tax revenue, and other ancillary economic benefits. And just to briefly touch on the equal protection claim, to state an equal protection claim as a class of one, as the appellants attempt to do, they have to show that they received disparate treatment from similarly situated individuals.
So is there any reason why, if we were to decide that Colorado River abstention is inappropriate here, why we should give the district court the first opportunity to look at these various additional theories that you're presenting? I mean, he didn't say a word about it because he thought it was Colorado River, and so that was that. And I'm not saying you didn't preserve it, but we very often try to give the district court the first shot.
Normally, I could see that being a reasonable option, Your Honor. But in this case, the complaint is relatively bare bones, and this court can affirm on any grounds. And the district court, in this case, is a dismissal. So the court may affirm the dismissal by looking at the allegations in the complaint, concluding as a matter of law that it does not state a claim for relief.
Okay.
So just to return to the equal protection claim, the similarly situated properties the appellants point to are larger. Many of them are larger. They're in different areas of the project. They were not taken for road purposes. They were taken and slated for actual development within the project by private entities. And many of those were complete takings compared to partial takings. And I don't think much needs to be said on the substantive due process claim other than this was not conscience-shocking conduct. Thank you, Your Honors. We submit that the court should affirm. Thank you.
Mr. Avalone, thanks to you. Mr. Olson, you have a little bit of time left. Let's round that up to a minute.
Well, I'd like to thank all of you very much for your time and attention. This is a situation where if this case had been brought under 32.06, that would have put us on notice that it was for Foxconn. If they had taken the entire property, it would have put us on notice that it was for Foxconn. They didn't do either of those things, and so as a result, our expectation was that there would be two separate takings, one for the road and one for Foxconn. It is in the area on the map, but it is at the very edge, and that left some question in our mind whether the roads were going to be characterized as part of Foxconn or not. And quite frankly, I thought on the record of how the jurisdictional offer came in under 32.05, how the plat came in, which shows only the road, and how the award of damages came in, that we would not have any chance of winning a private or public use argument or a right to take, however you want it. Those are essentially synonymous. So we didn't file it. If any of those other factors had been true, this would have been part of the other litigation, which was Jensen versus Village of Mount Pleasant, and it would have gone up through that process long ago. I feel, quite frankly, that the way that the village ran the taking on this left us in the dark as to what argument they intended to make later as far as the public use argument. I understand that they feel that I acted in a sharp manner. I didn't. I did my best, and I value my reputation quite highly. I've tried to work hard and seriously over the years. One last point I would leave this court with is that this did come in on a motion to dismiss. A motion to dismiss, at least under the Tomio versus Blagojevich case, is any possible inference. I'm not sure whether the actual law is any possible inference or any reasonable inference. Either way, I would say that our complaint has painted a possible or reasonable inference that the taking was for a private purpose when you read how Justice Kennedy characterized that in Kelo. And I would appreciate an opportunity, although I realize we have a steep hill to climb, I would appreciate an opportunity to try to prove that to the district court. I thank you all very much for your time.
Mr. Olson, thanks to you. Mr. Avalone, thanks to you. We'll take the appeal under advisement, and that concludes the day's arguments. The court will be in recess.